This is Debt Free in 30 Technical Tidbits Edition, where we answer short questions from our listeners about debt, money, and personal finance. Here's your host, Doug Hoyes.
My firm, Hoyes Michaels & Associates, posts a lot of information on our 310 Plan Facebook page, and we get lots of comments. Obviously, most of the stuff we post is about debt, so we get lots of people commenting on how to avoid paying debt without going bankrupt or filing a consumer proposal. It's very common for a commentator on our Facebook page to say something like, "Don't worry, if your debt is old, you don't have to pay it, it just goes away." Well, is that true? What actually happens to old debts? Do you have to pay them? Well, those are the questions I'm going to answer today on this Technical Tidbits edition of Debt Free in 30. Now, before we discuss what happens to old debts, let's start with a more basic question. What exactly is an old debt? Well, there are three possible answers to that question. It could be any debt that's past due, it could be any debt that's more than 2 years old, or it could be any debt that's more than 6 years old. Now, why are those 2 years and 6 years time limits important? Well, let's talk about the life cycle of a debt. So let's say you've got a standard unsecured debt, a credit card debt, a bank loan. We're not talking about car loans or mortgages. That would be a special case, but a standard unsecured debt, and you're not able to pay it. So what happens? Well, you miss the first payment and the original creditor, the bank, will send you a letter. They'll call you. They'll ask for their money. If after 2 or 3 months they're not getting anywhere with you, maybe 3 or 4 months, they will turn the debt over to a third-party collection agency. The bank doesn't want to be collecting from you forever. They turn it over to a collection agency. So I guess you could say, well, at that point, my debt is starting to get old because it's no longer with the original bank. Legally, there's no difference between a debt that's 1 month old or 6 months old. If you want to know more about how to deal with third-party collection agents, how to deal with collection agencies in general, we've got lots of information on our Hoyes.com website. I did a podcast with a collection agent, Blair DeMarco Wettlaufer. That was podcast number 20. So if you go to Hoyes.com and search for collection agents, you'll see all sorts of information on how to deal with them. Let's take a look at the second case where a debt that is more than 2 years old. This is a much more special case because in Ontario, we have something called the Ontario Limitations Act. Under the Ontario Limitations Act, and again, I'll put links to this in the show notes over at Hoyes.com, Section 4 of the Limitations Act says, unless this act provides otherwise, a proceeding shall not be commenced in respect of a claim after the second anniversary of the day on which the claim was discovered. Okay, that's a bunch of legal mumbo jumbo. What does that actually mean? It means that once a debt is 2 years old, it is very difficult for a creditor to sue you for that debt. When does this 2 years start? Well, if you look at subsection 5 sub 3, it says, for the purposes of subclause 1A, the day on which the injury, loss, or damage occurs in relation to a demand obligation is the first day on which there is a failure to perform the obligation once a demand for the performance is made. Now, I'm not a lawyer, and you should not construe anything I say as legal advice. I will tell you my interpretation of what that phrase means, and you can investigate it for yourself. But in common usage, it means the 2 years starts when you fail to perform your obligations, which is when you fail to make a payment. So if you are supposed to be making a payment every month and you stop making payments, then the 2-year clock starts at the time of your last payment, or what would show up on your credit report as the last activity date. So it's not when you got the loan that matters, it's when you stopped performing your obligations. It's when you stopped paying it that matters. So for the purposes of this 2-year rule, if you haven't made a payment for 2 years, then it is outside the limitations period. Now the Act says that, again, I quoted from Section 4, a proceeding shall not be commenced. In other words, a creditor is not supposed to sue you for a debt that is more than 2 years old, or more specifically, for a debt where no payments have been made in more than 2 years when they should have been made. In real life, what that means is if you have not made payments in 2 years, and if a creditor sues you, even though the act says they're not supposed to, you would be required to defend the action, either by filing a statement of defense with the court or, more likely, actually showing up in court on the date of the court action, the trial. It would probably be in small claims court. You'd show up in court and you'd say to the judge, hey, judge, the last activity date on this debt was more than 2 years ago. Therefore, according to the Ontario Limitations Act, they should not be able to sue me. That's how the Limitations Act works. Yes, it is supposed to prevent creditors from suing you, but if a creditor does sue you and the judge doesn't know that the debt is more than 2 years old and the judge doesn't know to ask, then they still could get a judgment against you, so you must defend yourself. That's the key point about the 2-year rule. So if you have a debt where you've not made payments for more than 2 years, then the Limitations Act works to your advantage. Now, I said that there were 3 time periods that mattered. When it goes to collections, well, we've already talked about that. The Ontario limitations period, which is 2 years, and it's different in other provinces. There's also your credit report. Information stays on your Equifax credit report for, in general, 6 years. More specifically, old information is purged from your credit report after 6 years. So when you get a copy of your credit report, most of the debts listed will have a last activity date. If the date is more than 6 years old, the information in general is automatically purged, because there's no point in having information on your credit report that's more than 6 years old. There's really no point. So that does not mean you don't owe the debt. It just means that it doesn't show up on your credit report. That's the difference between the 2 years and the 6 years. So before I explain what all this means in the big picture, let me tell you that there are some exceptions to all this. Things like tax debt, for example, are not subject to any limitations period. If you owe the government, you owe the government. And the only way you don't owe them is if you pay them or if you file a bankruptcy or a consumer proposal. That's it. So tax debt is not subject to the limitations period. Student loan debt, same thing. There are special rules that govern government debt, student loan debt being one of them. And in fact, as a general rule, any kind of government debt is not subject to the 2-year limitation period. Things like parking tickets, speeding tickets, those are all government-related debts. They're not subject to the limitations period. Alimony and child support, same thing. If you owe it, you owe it. Doesn't matter how old it is, you still owe it. Another example of a government debt would be like a CMHC shortfall on a house. So there are debts that are not included in the limitations period. If you have old debts, it's good to get professional advice, talk to a licensed insolvency trustee, talk to a lawyer, and figure out whether your debts apply or not. So let's summarize this by looking at what the whole point is. So the point is this. Just because a debt is old does not mean it goes away. Just because a collection agency is calling you doesn't mean you don't have to pay. They're still going to keep calling you. Just because a debt is over 2 years old, you still owe the debt. All that means is if the creditor was to take you to court and sue you, your defense, if you made one, would be that the debt is past the limitations period. You still owe the debt. They just can't legally collect it from you by getting a judgment in court. If a debt is more than 6 years old, it likely will not show up on your credit report. Doesn't mean you don't owe the debt. It just means at that point, they can't really sue you for it, and it's probably not showing up on your credit report. And again, there are certain debts that are not, that don't follow with these rules. So if it's a normal debt, like a credit card, and it's been more than 2 years since you last used the card or made a payment, it is still possible that the creditor could sue you. If they do, you have to appear in court to defend yourself, and your defense would be that the debt is older than the limitation period, and assuming the judge knows the law, the creditor won't be able to get a judgment against you. The key point is that if you are sued for an old debt, you have to defend yourself, or else the creditor is likely to get a summary judgment against you, even if the debt is old, because the court may not realize that it's an old debt if you aren't there to tell them. The bank may not be able to get a judgment against you if it's been more than 2 years since you made a payment, but you still owe the debt and it still appears on your credit report. If it's a government debt like taxes or a student loan or a CMHC shortfall on a house, it never goes away. CRA can keep taking your tax refunds and taking other action until the debt is paid. So if you have old debts, don't just assume you can do nothing. Don't believe everything you read on a Facebook page. Contact an expert, a licensed insolvency trustee, for the real answer in your situation. We may advise you to do nothing. We may say, hey, look, you're on a pension, you don't have any assets, it doesn't matter that it appears on your credit report, don't worry about it. On the other hand, you may say, hey, but I want to be reestablishing my credit, I want to be financing a car, buying a house in the future, I want my credit to be cleaned up. Well, if you've got a 2-year-old debt on your credit report, even though you can't be sued for it, probably, it's still showing up on your credit report. It's still negatively impacting your credit score. It may be a good idea to file a bankruptcy or a consumer proposal to deal with it. Or there may be many other options to deal with it. Maybe you can make a settlement directly with the creditor. The point is, there are lots of different options. Don't just assume that the do nothing option is correct for you. It might be, and if it is, we'll tell you. But if there are other options, you want to consider them. That's the point. That's our show for today. Full show notes can be found on our website at hoyes.com. That's HOYES.com, including a link to the Ontario Limitations Act and a list of all of our licensed insolvency trustees who can help you make a plan to deal with your old and your new debts. Thanks for listening. Until next week, I'm Doug Hoyes. That was Debt Free in 30.